Hey, I'm ERISA disability attorney Nancy Cavey. In this series of videos, we're talking about the mediation process, and we're just about to talk about how an ERISA disability case is valued. Unfortunately, it's about money. It's not about pain and suffering, loss of consortium. It's about how much your case is worth. And the starting point for that is the amount of your monthly benefits. Now, from that monthly benefit, we have to determine whether there are offsets or reductions. Those reductions can be for the receipt of Social Security disability benefits that you might get and those of your minor children. Now, that can complicate the calculations because once your youngest child reaches age 18, the family offset will drop off, and all we will be calculating in terms of the value of the case is the gross amount of your benefits based on your initial benefit, subtract from that the amount of your Social Security benefits. But there are other offsets. Let's say you have a workers' compensation case or a personal injury case. The carrier is entitled to reduce the receipt of your monthly benefits by the receipt of those benefits. Now, there isn't an exact answer for how that works because every policy is different. Some policies will only reduce your LTD benefits by the receipt of lost income benefits paid for PIP benefits, or as part of that workers' comp settlement or part of that PI settlement. So it's really important that your attorney who represents you in those areas, PI or workers' comp, looks at the language in your policy, and better yet, consults with your ERISA disability attorney so they know how to properly phrase the release and try to protect as much as that money as they can from the disability insurance company saying, hey, you got some money in your workers' comp case for lost wages and we're going to reduce your monthly benefits by that, but we're going to prorate it over a period of time. Now, once we know what your net benefit is, the next part of the calculation is how long does the policy provide that you're entitled to benefits. That can involve the application of a limitation clause in your policy. There are subjective medical condition clauses and mental nervous condition clauses that will limit the payment of your benefits to 2 years. And if that's the instance, the carrier is going to say, well, we only owe potentially 2 years of benefits. We're not going to look at this case through the lifetime value of the benefits or through the maximum period of time of benefits, which is normally your retirement age. Once we know the net amount of your benefits, the period of time, it's kind of easy to figure out math-wise what is the amount of your back benefits. But in terms of your future benefits, we're projecting those future benefits from some time, generally the date of the mediation, out to the end of the life of the period of benefits. And then we reduce that to what's called present value. It's sort of the reverse, if you will, of compound interest. But the way to think of it is what amount of money at today's interest rate would throw off the amount of these lump sum benefits over time. One of the big fights in an ERISA case is what the discount rate is, and the other big fight is your life expectancy. Because even though the policy may pay out to retirement, the insurance companies have actuarially designed studies that will show, based on certain medical conditions, that your life expectancy is limited. So they will also apply a mortality factor that they will never tell us about. They also will generally settle these cases in a range of 20 to 40%, even more, depending on where you live. Obviously, states where there is no discretionary clause, these cases will settle for more. And so you have to get your head wrapped around this. They are not responsible for paying for any raises that you would have gotten but that you didn't get because of your disability. It's a pretty simple math calculation, though there can be times when we don't agree on this, and it takes us some time to get there. I like to get the numbers agreed upon with the disability insurance carrier before I get to mediation, and as part of the preparation for my clients, I'm writing them a letter explaining how we got to those numbers and what the normal settlement range is. So you've got to have your expectations set properly when you walk in to the mediation. Let's talk about the actual mediation negotiation process that goes back and forth.